So can I ask you about that context? Because I actually kind of hear you making a slightly different argument. And it is, yes, the court has said that when these rules function as a statute of limitations, the presumption applies. But based on your original analysis or your original statement and what you say in the brief, I almost hear you suggesting that whether or not this functions as a statute of limitations, the presumption shouldn't apply because this is the removal context. And you say in your brief, the federal removal statute provides a comprehensive scheme that governs the allocation of judicial power in this way, that Congress has made this decision. And that seems to me almost to be like a different or separate argument from whether or not this functions as a statute of limitations.
It's just we've set forth a number of arguments for why this doesn't function as a statute of limitations. One of them is history and purpose, and certainly this doesn't function as a statute of limitations because if you look at sort of there not being a historical tradition that there is for statute of limitations, the separate historical tradition here is about strict construction and respect.
Lose if we disagree with you on the functioning of the statute? That's what I'm just lose the presumption point. My only point is I wonder if you have to be right about whether or not this functions as a statute of limitations in order to make your presumption point. That if you lose on that, then we do have to presume that Congress wanted courts to retain their equitable authority, as your friend on the other side says, in this area. And so then we jump to, has that been rebutted? Is there a clear command here? But I kind of hear you suggesting, and I don't know if this is right or wrong, I just want to put it out there. I kind of hear you suggesting that in the removal context, even if we look at a statute that relates to removal and we say, boy, this kind of functions like a statute of limitations, there are good reasons to believe why we shouldn't presume that nonetheless Congress intended for this to be an area where courts retain their equitable authority.
Yeah, no, I would say the reverse is true.
Okay, tell me.
Yes, if I would say that this whole context of taking transferring jurisdiction from one sovereign to another counsels for there not to be equitable tolling.
That's what I'm saying.
Yes.
What I'm saying is, regardless, we look at this statute and we might go, oh yes, this looks like the rights are being transferred. It looks like a statute of limitations. But does that necessarily mean that we should presume that Congress intended for equitable tolling to arise in this situation? And you're saying, regardless of how it functions in this situation, we should not presume that Congress wanted courts to have equitable authority because this is a removal context, and that's like a special thing.
Even if this court thought it was a statute of limitations, in this context, that would butt up against strict construction canons. I also would disagree with my friend at opposing counsel that this test is a clearest command test. There is not a clear statement test here. The test is the test that this court has articulated in Ariano, and that is we're looking at congressional intent. Is there reason to believe that Congress didn't want equitable tolling? And everything here from the text, the structure, the history and the purpose strongly suggests that Congress would not have wanted tolling. We haven't talked a lot today about the exceptions, but when you look at the clear mandatory language, shall file in 30 days, and that's supported by a very comprehensive scheme that has at least 6 exceptions, and those exceptions are interrelated. They're the default deadline of 30 days is repeated multiple times, similar to in Brokamp. And similar to in Ariano, you have these many exceptions that are taking a situation outside of the default rule.
Can I ask